So we have studied until chapter 7, we have completed. Chapter 8, search and seizures, we are into that. In this particular video, we'll read uh, continuing from the previous one, and we have completed section 49 in chapter 8, search and seizures. We'll move to chapter section 98. We had completed 97 here, so 96 to 110. So section 98 says, it is a power to declare certain publications forfeited and to issue search warrants for the same. So what it says is, where any newspaper or a book or any document, whatever it is, wherever printed, appears to the state government to contain any matter the publication of which is punishable under section 152, 192, 197 or 294, 295, 299 of Bharatiya Nyaya Sanghita. So these things are mostly which are connected to voyeurism, some kind of uh, illicit things, some kind of things which are against the nation, etc., etc. So normally these things are said. So I'll just give you 182 is something which is endangering the sovereignty and the unity and the integrity of India. So which is something which is against the integrity of the country. While 96 is promoting enmity between various groups and religions, etc. 197 is something imputation, assertion, and prejudicial to national integration. This is also again. And 294, 295, basically, these are connected to a sale of obscene or obscene object to the child, which is harmful to their going through, if they go through that. And 99 to 99 is deliberate and malicious act intended to outrage religious feelings. So anything related to one religion instigating the other religion. So basically, in nutshell, if we see all these sections, it is basically something which is against the integrity of the nation, order in the country, in case of the various religions staying peacefully and calmly, obscene things and obscene things to the children. So the state government, if it feels so, may by notification stating the grounds of its opinion, declare every copy of the issue of the newspaper containing such matter and every copy of such book or other document to be forfeited to the government, and thereupon any police officer may seize the same wherever found in India, and any magistrate may, by warrant, authorize any police officer not below the rank of sub-inspector to enter upon and search for the same in any premises where any copy of such issues or any such book or other document may be or may be reasonably suspected to be. Now, this is a little wide. Let's go ahead and break it into small chunks. So basically what it says is, wherever at any place, any printed article, so newspaper, book, any document, anything. So it is appears to that state government. So this is a jurisdiction of the basically of the state government to take a notice of this. Of course, there might be reasons from emanating from public or various other organizations to highlight that, but then it is something which is a which is an authority to the state government, and if they took any matter and a publication which is punishable under so and so sections, the state government may go ahead and publish a notification by putting the grounds on which it feels it is violative of these sections, and they can declare that every copy in that notification, they can declare that every copy of that particular content is something which is has to be forfeited to the government. So it has to be brought to the government. So selling, buying, anything is also prohibited in those notifications. So that is has to be forfeited. This is also done sometime for the Naxal related books, articles, etc. also. And every copy of such book or such document to be forfeited to the government, to be brought to the government and deposited with them. And any police officer, irrespective of rank, irrespective of having a warrant or not, or irrespective of having any authority or specific of authority given to him or not, may seize the same wherever found in India. So the police officer, wherever it is found in India, they can go ahead and they can pick it up and they can impound it and forfeit to the government. While in case if either by intimation by some person to the court, or by the police to the court, or by the own will of the magistrate on some information or some kind of application to it, the magistrate may issue a warrant. So basically, what it means is to search and seize for such kind of articles to be taken out from the premises where it might be reasonably suspected to be present or stored there. It has to be a warrant which has to be issued to a sub-inspector rank police officer minimum, and that must authorize that person to enter the premises. So what does it mean? If the reverse understanding is the police officer can pick up such thing across India if that state has definitely gone ahead and that did a publication through a gazette or any notification, but they cannot enter any premises and do a search. So to enter a premises, they have to again go formal permission from the magistrate. So this is allowed, but the limits of the power of the police is only up to the open eyes in the public place, not into the private area search. Now, number 2 says in this section and in section 99, a newspaper and book has the same meaning as the press and registration of book. So this is just a definition defining what exactly is the book. And document include any, not only the book, paper, etc. It is also a painting, drawing, or photograph or other visual representation also. So anything which is printed or which is visible. So no order passed or action taken under this section shall be called in question in any court, otherwise than in accordance with the provisions of section 99. So uh, whatever has been ordered, whatever order has been passed under this particular section cannot be challenged further until and unless this is something which is challenged into the under the section 99, and which has in plain reading means anything which has to be, or an appeal or a petition has to file in the high court. So until and unless somebody reaches an high court, no other court has a jurisdiction to go back and where it could be challenged. So this is a forfeiture of any publication which is mentioned in this particular section. So subsection 1 says that state government to declare copies of anything which we have just discussed to be forfeited to the government if it is, while declaration, it is already cleared that for what reasons it has to be forfeited. And it is something related to morality, public order, national integrity, religious sentiments, protection, etc., etc., and it has to be forfeited to the government. Power to seize this kind of declared items is the police officer are authorized to seize the uh, offending material wherever they are found in India. Wherever they are found in India. Now, this has a connection with the uh, section where they have to go and do a search and warrant also. So any offending material where they are found in India, they can go ahead and find. The broad authority allows them to act swiftly in removing potential harmful publication from circulation as soon as possible. But it has two meaning. One meaning is that the police officer are authorized to seize offending materials wherever they are found in India has two meaning. One is he can find anything in front of his eyes in a public place. He can quickly collect it, seize it, and forfeit it to the government. While the other meaning of the same statement, police officers are authorized to seize the offending material, is the police officer, if believes that it is in the some kind of premises it is stored, then the same police officer can get a magistrate warrant issued and then get himself authorized and go ahead and find and search into the premises also. But then in that case, that police officer has to be a sub-inspector level at least. What will happen is, in case if a police officer of the rank lesser than of a sub-inspector notices that in the public place, he is allowed to pick it up. But the moment gets an information about the same is present in some premises. In the previous section, what we have yesterday, he has to become then an informant to the police station. His senior officer, he has to inform, and then the police officer will take a notice of that and deploy a person at least of a sub-inspector level on the matter to go ahead, get a warrant and do that search. So these particular same statement has three applications. One application directly from public, any rank. Second, if the person is of sub-inspector or above rank, he can go ahead and get a warrant issued and do that particular search and seizure. or if the person is not of that relevant rank of a sub-inspector and below that, then he has to go back and inform his superiors and get a person deployed at least at the rank of sub-inspector by the police station in charge and get a warrant issued against this particular premises and make a search. So if we see, there are two statements made in the section about the police officer authorized and police officer to get warrant. These are part of the same particular activity, but only differing on if it has to be under an enclosed scenario and if it is to be searched by a certain rank, if it is a enclosed scenario. So key terms are also defined in this section, which is fine. Newspaper and book. What are they? What is the definition? So Press and Regulation of Book Act defines what is a book, what is a newspaper, etc., etc. And no order or action under this section can be challenged in a court except in High Court. So the seriousness is something which is included, and that's why it can be only challenged in a session as a High Court. Because until and unless there might be not be very strong reasons, and these are very strong reasons, national integrity, obscene object, which is something related to morality, against morality of the children, etc. So all these things are very serious subjects. And if a state government is taking a step, being the ultimate administrator of the state, the seriousness is far more and the responsibility is far more. So that in that case, it can only be challenged by the High Court of that particular state. So what is the purpose is prevention of a harmful publication to be circulated, which might be create hatred, pollute mind, degrade morality, ignite violence, etc. And there is a judicial oversight, very strong judicial oversight attached, where in case search and seizure in a premises has to be done, then that has to be done with a warrant. While if it has to be challenged, it can be challenged only at the level of a High Court. So this also brings in a clarity and consistency in the enforcement of these kind of activity. Let's move to section 99, which is, we just mentioned, application to High Court to set aside declaration of forfeiture. So what is the procedure given? Any person, subsection 1 says, any person having any interest in any newspaper, book or document. So it might be the publisher himself also. Of course, the person who has an interest will be the publisher, financer, etc. Who is person who is connected with that concept, the person who conceptualized the particular magazine, etc. So the person having an interest in any newspaper, book or other document. So what does this first line means? Learn to understand it in a other way around also, which means no person who does not have an interest can. So in respect of which a declaration of forfeiture has been made under this section 98 may within 2 months of time. So there's a limitation period given within 2 months of time from the date of publication in the official gazette of such declaration apply to the High Court to set aside such declaration on the ground that the issue of the newspaper or the book or other document in respect to which the declaration was made did not contain any such matter as is referred in subsection 1. Now, this is a lot of historical cases are there which you can find and read easily where it is also a political in nature. Sometimes one of the political parties or some central government might not like certain publications, which is against them. And this was very easy earlier in earlier days where politicians used to get forfeiture orders against such newspaper and magazines, etc., which were always many times set aside by high courts and the Supreme Courts. And this is something which is also actually applicable on couple of obscene magazines also. In one of the famous cases in Tamil Nadu, there was an obscene magazine which was uh, declared to be, which is something has to be forfeited by the state government. But later it won the case saying it is actually not an obscene literature, it is an adult literature. So between an adult and an obscene literature, there is a differentiation. So subsection 2 says every such application shall, when the High Court consists of 3 or more judges, be heard and determined by a special bench of the High Court composed of 3 judges, and where the High Court consists of less than 3 judges, such special bench shall be composed of all the judges of that High Court. So basically, every such application, wherever it comes. Now, this is, as I said, this is a very sensitive subject. And being very sensitive subject, and this is being declared by the highest administrator of the state, which is the state itself. So it has to be going to the High Court. And High Court, it has to be consisting of 3 or more judges, because they can take a census on the particular judgment to definitely ensuring that there is no bias or there is no judicial uh, discretion applied by the judges which is biased. It has to be heard by a special bench of the High Court composed of 3 judges. So if there is a High Court which has 3 or more judges, so it has to be 3 judges minimum. And where the High Court consists of less than 3 judges, then all of the judges, whatever is available, which is 2, 1 or 2. So they have to come back and make a judgment. Subsection 3 says, on hearing of such application with reference to any newspaper, any copy of such newspaper may be given in evidence in aid of proof of the nature or tendency of the word, signs or visible representation contained in such newspaper in respect of which the declaration of forfeiture was made. So in such hearing, the sample has to be given, and that has to be proved in the either way by either of the parties on the nature, the tendency, what exactly is trying to do, what is the nature of the language, what are the choice of the words, what is the, if there is an image, what is the kind of sign it is making, or if it is written statement also, what kind of indication it is making, and if it is a picture, what kind of visual representation which is obscene, etc., has to be represented in the court. And subsection 4 says the High Court shall, if it is not satisfied that the issue of the newspaper or book or other document in respect of which the application has been made contain any such matter as in referred to subsection 1 of 98, set aside the declaration. So High Court, if satisfied, can set aside. And subsection 5 says where there is a difference of opinion among the judges from special bench, the decision shall be in accordance with the opinion of the majority. So they can take a census. That's what I said. So basically, it is a right to challenge the forfeiture. We have seen yesterday right to challenge the proclamation. So every person gets a fair chance to challenge and establish their right, and that is where the right to challenge to forfeiture is given by this particular section. And subsection 1 says whoever has an interest can come back and find within 2 months of time may apply to the High Court that this particular after publication of the forfeiture in the official gazette, within 2 months he or she has to come, and then they can contest if the forfeiture is believe whatever it is under whatever grounds it is made is not correct and it does not contain that prohibited materials. Now, there is a special bench which is marked. So, in case there is a High Court which has more than 3 or more judges, it has to be 3 judges. And if it has less than 3 judges, all of the judges has to be part of the special bench. It will be a special bench taking care only of this matter. Now, evidentiary provisions are also given under subsection 3, which says a submission of the copies of these materials has to be also brought forward to bring as an evidence in support of or in against it by either of the parties. But thus, it has to be brought to support the proper examination of the content also. And it can also enable the court to assess also what exactly was considered obscene, etc., which it is not. The court has a decision on the forfeiture, and it mandates the High Court must set aside the forfeiture declaration if the publication is not either way creating any such problems. And in case of there is a difference of opinion between the judges, a majority has to be taken place. So this is a legal recourse for the affected parties who have the owners or who are the have interest of in these publications, and a judicial oversight of the state action is attached here. So this judicial review is something which is coming in picture here, where the state action is being reviewed through judiciary on invoke from a party who is interested. So once they invoke it, then it has to be scrutinized by the court through judicial review and ensure the right results are drawn. And it is reinforcement of the freedom of expression also. We know freedom of expression is something which is not ultimate. There is a limit where the freedom of expression has to be capped, and not people are not allowed to go ahead and do freedom of expression which might impact these key areas, which is something which is mentioned in section 98. through various sections of Bharatiya Nyaya Samhita, BNS. Now let's move to section 100, which is search for person wrongfully confining. Now, if any district magistrate, an SDM, or magistrate of the first class has reasons to believe that any person is confined under such circumstances that the confinement amounts to an offense, he may issue a search warrant, and the person to whom such warrant is directed may search for the person so confined, and such search shall be made in accordance therewith, and the person, if found, shall be immediately taken before a magistrate, who shall make such order as in the circumstances of the case seems proper. So, what is this section talking about? It talks about the authority to issue a search warrant for a person who might be legally confining. So, who all can, on reasonable belief, can do this, pass this order? Is a district magistrate, a sub-divisional magistrate, or magistrate of the first class. So the executive magistrate and the judicial magistrate both have the reasons. Now, this for to issue the such warrants, that if they believe on reasonable ground that the person is confined in a manner there that contributes to an offense. And this legal provision then enable them to timely intervene in case of such unlawful confinement and ensure that the right of the individuals are protected and established. Now, why there the executive and the judicial magistrate both are there? Because the executive magistrate might have a information on such things, being somebody who is part of the district administration. So they might have a secondary, tertiary information, primary information also about such thing happening somewhere, and they could come back and take a go ahead and issue a search warrant, or a magistrate who is a judicial magistrate, minimum at the level of JMFC, has to come back and give such a search warrant in case if the he is made aware of the same. So, search for the confined individual is the second part of the section, which says that the warrant authorizes the law enforcement officers to search the person who is believed to be wrongfully confined. And this is a proactive approach to justice. So it allows the authorities to act swiftly to investigate and potentially rescue the individuals who might be suffering from unlawful detention or confinement. Now, the search procedure is given in the section is, it has to be in accordance with the stipulations which is outlined in the warrant. The warrant will have the detailed mentions about how the search has to be carried on, and the procedural requirement ensure that the search is carried out lawfully and respect the right of both the confined individual and the person conducting the search. So basically, they are also doing it properly, and the other person is also safeguarded. And it is a immediate judicial action, because if either of the magistrates, judicial or the executive, receive such kind of information, there is always a sense of urgency, because God knows what will happen in the confinement with the person. So it is a protection of the individual right which is established. It strengthens the rule of law, and it is again under the judicial review when it is done. Section 101 talks about power to compel restoration of abducted females. So, upon complaint made on oath of the abduction or unlawful detention of a woman. So, on a complaint which is made on oath on the abduction or unlawful detention, so somebody is abducted or detained somebody of a woman or a female child, or any unlawful purpose. So the lady or the child, female child, has been either abducted or detained for some unlawful activities. A district magistrate, a subdivisional magistrate, or a magistrate of the first class may make an order for the immediate restoration of such woman to her liberty, or of such female child to her parents, guardian, or other person having the lawful charge of such child, and may compel compliance with such order using such force as may be necessary. So whatever limit of force is required reasonably, it has to be applied, and they will ensure to compel the compliance with such order through the such kind of force to be applied, and the restoration of that particular person's uh, liberty is immediately done. So what are the grounds of action in this particular section is that it allows a this DM, SDM or a JMFC to take an action upon receiving a sworn complaint regarding the abduction or unlawful detention of a woman or female child. This provision ensures that there is a formal legal basis for initiating action helping to safeguard misuse. So the person has to, whoever is putting the application has to put it under affidavit or some kind of oath the person has to take and ensure that that is something which is not this is eliminating a misuse and creating a liability on the person who has come back and informed the to initiate this legal procedure. So that is one thing. So second thing is the order of restoration is has to be done immediately. So on receiving such a application request on oath, then the responsibility is on these particular people who are the DM, SDM or the JMFC to order the restoration ASAP. Immediately they have to do, and they have to return the woman to her liberty or to the female child to the lawful parent, guardian or any other individual who is taking the custody of this child and most appropriate to take the custody of the child. And this is something which is done with a sense of urgency and to ensure that the person, the lady or the female child is, their liberty is ensured, secured immediately. So what are the basic things what is coming out in this section is this is a protection of the vulnerable individuals. Some of the vulnerable individuals are defined, and the females and the female child is somebody who is considered a vulnerable characters in this particular section, and those are protected. Then a swift judicial intervention is required. So the moment a sworn in, which is a confirmed on oath request coming in, which becomes the basis of quick action. If there is a on sworn in or on oath, some application is coming in, they have a basis to take action. So by making that basis, they have to make a swift action to quickly put an order to ensure the restoration with whatever force is required. So when force we talk about whatever law enforcement officials there they need, they can ask them to go ahead and execute that particular order to ensure the person is his liberty is restored. And this gives a effective tool for the law enforcement officials to carry out a restoration of the victim and further ensuring the justice system. So this is a very important section 101, which talks about any of these executive officers, magistrates or the judicial magistrate to help swiftly by applying whatever force has to be applied, a restoration of the freedom of these vulnerable individuals, the females and the female child. Section 102 talks about directions, etc. of search warrant. So there are provisions of section 32, 72, 74, 76, 79, 80 and 81 shall so far as may be apply to all search warrant issued under section 96, 97, section 98 and section 100. So what it says is all the provisions which are under section 32, 72, 74, 76 are applicable in these sections also, in these 9 series of sections, which is the section 32 is act to which a person is compelled by threat, etc. And many other such sections which is mentioned here, all of them has to be applicable in case of these people also. So let's quickly have a look on section for refreshing. Let me read. So section 32 talks about aid to a person other than a police officer in executing a warrant. So if the person who is the directions, etc. See, this is a bouquet section which has which is picking up information, meaning, and purpose and process from all these sections and applying it to section 96, 97, 98, and 100. And this is what the direction it is giving. So 32 section was of aiding a person other than a police officer. In case of such a search warrant has to be issued to a private person, Section 32 will be automatically applicable when these sections are used for search and seizures. And then we talk about Section 72 is form of warrants of arrest and duration. That is, or definitions are warrants to whom to be directed is 74. 76 is warrants directed to a police officer, then what it happens, how it is done. Section 18 is warrant forwarded to a execution outside the jurisdiction, and 81 is warrant directed to police officer for execution outside jurisdiction. So all of these are nothing but these are the procedures defined in specific areas carried by specific people, etc. And this has to be automatically applied to this section, and that is what this section signifies. So this is why by bringing a reference to all those sections, what does it mean is it refers to all the other sections to bring a consistency in the legal procedure. We have seen one example where the definition of the receiver was picked up in CRPC or BNSS from CPC. So that is why reinventing the wheel, as we say. Instead of doing that, this is a block approach where the references from various other sections are constructed and the meaning is brought into that section to make it a combined effect into than the sections where it is directed to. So this is a technical section basically, which is doing nothing but it is redirecting that all such provisions, all such methods are applicable to these sections when they are applied to. In these scenarios also. Let's move to section 103, which says persons in charge of closed place to allow search. So this is something which is also referred in many other sections, this section. So subsection 1 says wherever any place liable to search or inspection under this chapter is closed. So under this chapter means anything related to search and seizure. So if the place is closed, any person residing in, so somebody who is already inside or who is in charge of such place, shall on demand of the officer or other person, whoever is executing the warrant. So we know who would execute the warrant. We have understood from the previous section where the references are given, and on production of the warrant. So when the warrant is given, allow him a free ingress thereto and afford all reasonable facilities for a search there. Now we know for sure that search in the enclosed place has to be supported by a warrant. The warrant, what the warrant will have? The warrant will have the reason, the place, what has to be searched, what is the way it has to be done, and what all has to be found in that place. What is the expectation? So at least the indication of that. So all those things are mentioned in the warrant, which is issued by a magistrate. So if the place is closed, and the inspection has to be done, which means the warrant authorizes the person to go ahead and check. In that case, the person who is residing in or the person who is in charge of that place, etc., on demand of the officer for an ingress to go inside while production of the warrant, that person has to allow the ingress of those officials or the person who has been assigned the warrant to go inside and facilitate the search for that person. So open all the locks and keys, make a provision for a person to be comfortably in, switch on the lights, whatever provisions has to be made to ensure that he is able to do that search. Subsection 2 says, now if ingress into such place cannot be so obtained. So for whatever reason, if the ingress cannot be obtained in that manner where a warrant is shown and person is given ingress, the officer of the or the other person executing the warrant may proceed in the manner provided by subsection 2 of section 44. So we have seen section 44 earlier also. Let me, for refresh of your mind, let me read the provision of section 44 for you, which is section 44 subsection 2 says, if ingress of such place cannot be obtained under subsection 1, it shall be lawful in any case for a person acting under warrant in any case in which a warrant may issue, but cannot be obtained without affording the person to be arrested an opportunity of escape for a police officer to enter such place and search therein, and in order to effect an entrance into such place to break open any outer inner door or window of any house or place, whether that of the person to be arrested or any other person, if after notification of this authority and purpose and demand of admittance duly made, he cannot otherwise obtain admittance, provided that if such place is an apartment in an actual occupancy of a female not being the person to be arrested, who according to custom does not appear in public, such person or police officer shall, before entering such apartment, give notice to such female that she is at liberty to withdraw, and shall afford her every reasonable facility for withdrawing, and may then break into the apartment and enter it. So basically, nutshell, we have talked about 44 yesterday also, is to allow him to use force to break into the doors and windows and go inside, only with an exception which is given, a precaution actually given, for to be sensitive of a parda nashi or somebody who is not allowed to be seen by the world. And in that case, if she is not the one whom we are searching for, in that case, it is suggested that as much as possible, they have to allow that person to withdraw and then they have to enter. So the first condition was about the warrant is issued and the person goes inside. All the facilities are provided to him to make a search successful. In case doesn't possible, break into it. Subsection 3 says, wherein person in or out on or about such place is reasonably suspected of concealing about his person any article for which search should be made. Such person may be searched, and in such person is a woman, the search shall be made by another woman with strict regards to decency. We have studied this yesterday. So basically, if the who is person who is in or about such place, close to that place, very close, is reasonably suspected of concealing something from which for which a search should be made, so then that person may be searched. And if a woman, it has to be done a woman, and as we said yesterday, in spite of a woman, it has to be with a limits of decency. It has to be done in civilized way. So if we see sequentially, one is proper scenario, standard scenario where warrant shown, go inside, search. 2, not allowed, not possible, nobody is there, locked, break open and go inside. And 3, in case even if apart from the place, the person is also hiding something in or near, close by to it, it is allowed to search that person, man or woman, depending upon how it has to be done. Subsection 4 says, before making a search under this chapter, the officer or a person about to make it shall call upon 2 or more independent and respectable inhabitants of the locality in which the place to be searched is situated, or of any other locality if no such inhabitant of the said locality is available or is willing to be witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them so do so. So before we even do this 1, 2, 3, there has to be 2 punch who has to be brought in from the same locality, different locality, or somebody who has volunteered to be that. And there is a possibility of, if they want, they can also issue a written order to them or any one of them to come and be witness the search and the seizure. Subsection 5 says the search shall be made in their presence. So those people who are brought in, it has to be done in their presence, and a list of all things seized in the course of such search and of the places in which they are respectively found. So whatever is found and where it was found, we found 5 kgs of gold in a metal almirah, which was marked as a Godrej. It was kept on the south side of the first room on the entry. Such kind of thing has to be written by the search officer or other person and signed by such witness. So these people have to, the police officer or the person who has received the warrant and is a non-police officer, they have to make that right. For example, in a recent trademark case, which is running in the High Court, our matter. So basically, this companies, when they come for a trademark violation, they are given a first opportunity if they are coming making a complaint that the order is kept secret from the other party. It is not even shown on the websites of the High Court as orders, and then a preliminary and interim relief is given to the party with their advocates being converted into the court receivers. They go to the place and together with the help of the local police do a search and seizure of that place, and they recover everything from that place. So when they do that, they bring 2 people sometime nearby who are the punch. And when they make that list, they are not police officers. They are supported by the police officers, but they do that search. They do the seizure with help of the police. They make a list. which is signed by two witnesses. In these cases, sometimes the police officer also from the other police station can also become a witness. So they have to make a list and it has to be signed by the uh, the witnesses. But no person witnessing a search under this section shall be required to attend the court as a witness of the search unless specially summoned by it. It is not required, it is immaterial mostly, but then if required, they can come only by summon, but by default, they are not supposed to come. Subsection 6 says the occupant of the place searched or some person in his behalf shall, in every instance, be permitted to attend. So, if there is an owner in the first place, the person is allowed, or in number two, when ingress is forceful. So, in all those cases, the owner, if comes down, has to be, or person who is controlling that place is come down, they have to be uh, permitted, they are permitted to attend during the search, and a copy of the list prepared under this section signed by the said witness shall be delivered to such occupant or person. So the person will also receive who is the owner of that particular place. Subsection 7 says when any person is searched under subsection 3. What is subsection 3? Where reasonable suspect of concealing something on his person. So when a person is searched and under subsection 3, a list of all things, we have studied it yesterday also, that on person, only the basic clothing, etc., has to be left on the body and everything else has to be recovered, listed for the purpose of preserving it. And what if there is a weapon which is required? Another section is applicable where it has to be again brought forward to the magistrate to show that what is recovered, and a copy has to be delivered to such person. So a person will also sign that and the copy will also received by him. Subsection 9 says any person who without reasonable cause refuses or neglect to attend and witness a search under this section, when called upon to do so by an order in writing delivered to or tendered to him, shall be deemed to have committed an offense under section 222 of Bharatiya Nyaya Sanhita. So we talked about people who could be given a written order and that person has to then come and join that particular search and seizure, being a witness to it, and that person has been given a written order. So the order has been given in advance to that person that you will have to come and you have to be witness of this such and such search and seizure, what is happening, and then you have to make a sign as a witness on so and so date and so and so place. If that person doesn't comes in, then the omission to assist a public servant when bound by law to give assistance, that particular section from BNS is applicable, and the person is then considered to commit an offense under section 222 of Bharatiya Nyaya Sanhita. So this is a duty to allow access, which is of the persons who are owner, etc., for that particular premises, and it is the responsibility of them to allow the police officer to enter. Of course, they can demand to see the warrant to understand if it is a something which is actually pointed towards their premises and what else has been written in the warrant. Alternate action is, of course, if it is refused, force is the other option, so they can forcefully break inside. And search of individual is also allowed in case there is enough suspicion that whatever we are searching, that person might be hiding within himself or herself. And witnesses are very much required. So before you get into all such actions, you have to ensure you are summoning some of the witnesses or who have either volunteered themselves or they are already there in that locality, and they have to be the witness and sign as witness. They although also they are not required to be part of any of the further trial regular proceedings, but in case if they are summoned, they have to come. And it also saves the occupant's right of the particular occupant also, where if any such thing is happening, he is allowed to be part of it. He is to be allowed to stand there, and he can also receive a copy of that. And the person also who is searched, his rights are also preserved, and whatever is done listed coming from his body, a list is made, signed by him, and a copy is given to him. So this is all which is given. There is a legal consequences and penalty for individuals also who refuse to or neglect to attend and witness a search when called upon by police officer via written order. So if they are not coming, they are obstructing, because in that case, then police will not have that kind of witness signature, which is mandatory, and they might lose some precious time and effort. And such refusal will be treated as per section 222 of the Bharatiya Nyaya Sanhita, and it is also making accountable the person who is going to be witness. So it ensures an effective law enforcement to ensure that the protection of individual rights are also taken care. Gender sensitivity is also taken care in case of search and seizure. And this is about section 103, what we have seen now. Now let's move to section 104. So section 104, let's read the wordings first. So section 104 says, disposal of things which are found in search beyond jurisdiction. So if anything which is searched and found which is beyond jurisdiction, which means when in the execution of a search warrant, so when a search warrant is being executed in any place beyond the local jurisdiction. So the place where the search is made is beyond jurisdiction of the court which has issued the same. Any of the things for which search is made, because search is made for a specific thing at the specific place, which the court has to ensure they are putting that on the warrant. Any of the things for which the search is made are found, such things together with the list of the same prepared under the provisions here and after contained shall be immediately taken before the court issuing the warrant. So it has to be sent back to the issuing court unless such place is nearer to the magistrate having jurisdiction therein, that to such court, in which case the list and things shall be immediately taken before such magistrate, and unless there be good cause to the contrary, such magistrate shall make an order authorizing them to be taken to such court. So then in that case, it has to go to, if the magistrate is closer, the other one, then it can be going there. Otherwise, it has to be going to the original magistrate only, and the magistrate will make a decision depending upon his uh, discretion or depending upon the jurisdiction, etc., either to pass it on to some other magistrate. So basically, this section is talking about the jurisdiction when it is outside. Now let's read section 105. So section 105 says, recording of search and seizure through audio video electronic means. So now BNSS has been advocating a lot of the digital use cases. So recording of search and seizure through audio video electronic means, which means 101 says the process of conducting search of a place or taking possession of any property, article, or things under this chapter or under section 185, including preparation of the list of all things seized in the course of such search and seizure and signing of such list by witness shall be recorded through any audio video electronic means, preferably mobile phone, and the police officer shall without delay forward such recording to the district magistrates, SDM or JMFC. They have to immediately give it forward it back to them. So what it says is the search and seizure, whatever is happening. So every step of that. So taking possession, search of the place or taking the possession of the articles or whatever things, then including the preparation of the list, when it is being prepared, which is seized in the course, and then search and seizure, then it is signed by the witness. Everything has to be recorded on a audio-visual device, which is something which is preferably always a mobile phone. This is specifically quoted because otherwise people will believe they have to hire some video cameras. So that is why it specifically says preferably it is mobile phone, and then it has to be forwarded to the DM, SDM or the JMFC of the first class, depending upon from where the search has originated. Because we have studied today in the earlier sections, that the search can originate from the executive magistrate also, judicial magistrate also. So whatever was the source originator, that is how it goes back to that particular person. And it says that under that possession of any property, article, or during things under this chapter or under section 185. So it says whatever is the procedure given by audio video recording at what stage is also which is applicable to the search by the police officer under section 185, where officer of charge police station or police officer who is making an investigation for reasonable ground, if they believe that there is a uh, offense which is committed, and there are things which could be immediately which has to be recovered without any delay, and they have to go into search and seizure. We have studied about this 185 earlier in chapter 8, and chapter 8 we will study it again, sorry, and we have seen it in the previous module also. So 185 is specifically coming in further in this chapter only, but then basically it nutshell, it is something where a police officer in charge is allowed to make search and seizures immediately if there are reasonable ground by making an entry into the diary, and that is something which also has to follow the similar process where, as per this section 105, the requirement of recording is attached, where in it is done from the time of search, showing the seizures, showing the preparation of the list on camera, showing the signing of the by the list by the witness also, and everything has to be recorded and sent to back to the originator, which is either the executive magistrate or the judicial magistrate who has initiated and ordered this search warrant. So it is an enhanced accountability. When the cameras are on, audio and video both, then people are careful. The search will also be done properly, and the cooperation will also will come. And even there is a very less chance of misusing the authority to search and seizure by the concerned officer or the person to hide things or manipulate things, etc. Because the recordings has to be consistent, and it has to be in one shot. So this is also other way, it is also protecting the right of the persons also there, because if they are the search and seizure shows whatever has happened at that point of time, it cannot be manipulated later point of time. It is something which is recorded and frozen in the time, that point of time. So this is section 105. Let's talk about section 106 now, which is power of police officer to seize certain properties. Certain properties. So subsection 1 says any police officer may seize any property which may be alleged or suspected to have been stolen. So this is one of the certain properties we have mentioned, indicated in this section, is stolen property, or which may be found under circumstances which create suspicion of the commission of any offense, or some property which looks like to be which creates a suspicion where it might be used for commission of any offense. So subsection 2 says such police officer, if subordinate to the officer in charge of a police station, shall forward report the seizure to that officer. So if the person is in a subordinate of a police officer in charge, so if the police, as I mentioned earlier also, the police officer in charge is somebody who is the in charge of that police station, and his powers are imbibed into the subordinates depending upon the levels of the police officer, and he operates through those officers. So everything, the final, if you have seen earlier also, we have discussed the charge sheet, the police report part. So only the police officer in charge has a right to go back and report back to about the charge sheet, etc. from the police station. So it is a responsibility of the police officer who is the in charge. In that case, the police officer, whoever is done it, and if the person is not the officer in charge of the police station, he has to go back and report to that officer who is the station in charge of that police station, because it is his responsibility, is in his jurisdiction, to ensure he is aware and reporting to the necessary judiciary or any other authority to about such search and seizure. So to enable him to do that, the subordinate has to go back and explain and share that to him. Subsection 3 says every police officer acting under subsection 1, which is searching and seizing anything which is stolen or something which is connected with an offense. So any police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction, and where the property seized is such that it cannot be conveniently transported to the court, or where there is difficulty in securing proper accommodation for the custody of such property, or where the continued retention of the property in police custody may not be considered necessary for the purpose of investigation, he may give custody thereof to any person on his executing a bond and undertaking to produce a property before the court as and when required, and to be given effect to the further orders of the court as to the disposal of the same, provided that where the property seized under subsection 1 is subjected to speedy and natural decay, and if the person entitled to the possession of such property is unknown or absent, and the value of such property is less than 500 rupees, it may be forthwith to be sold by auction under the orders of the superintendent of police, and the provision of section 505 and 504 shall, as nearly as much practicable, apply to the net proceeds of such sale. So what it says is it's a big subsection which talks about that every police officer which is acting under this subsection 1 shall report the seizure to the magistrate. So it has to be reported to the magistrate, because the magistrates will then make a decision on top of this to ensure what happens to these kind of things which are searched and seized. So do not get confused by subsection 2 and subsection 3. Subsection 2 is a hierarchy in the police station to ensure the accountability at the police station level, which means when the search and seizure happening within the police jurisdiction, it cannot happen that the person who is in charge of the police station is not responsible for such a kind of seizure. So 1 and 2 is nothing but internal police technicalities, where if the person who has made a seizure is not a police officer in charge of the police station, he has to align with that particular police officer who is a station in charge, so that the response then is recorded and sent via through the police station in charge. So when we talk about subsection 3, it is now a police to judiciary. 1 and 2 is police to police within internal alignment to ensure it is in the notice of the in charge also. And when the police officer act and goes to the magistrate, he will always go under instructions from the senior officer who is the police officer in charge of the station, and under his sign and seal that particular application will go. So 1, 2 or 3 are completely different things. Do not mix, it should not give a message to you or confusing that when the person goes to the magistrate, when the person goes to the police officer in charge. No, the police officer in charge it goes, which is a part of the procedure of seizure, where it has to be reported to the police officer who's in charge. 3 is talking about then police has to report everything to the magistrate, and that is why it is mentioned there. They have to report to the magistrate, which means even after reporting to the police officer in charge, under the sign and seal, the application will move to the magistrate through the police officer. He might be the same police officer or other police officer which might be appointed to take that particular matter to the judiciary. So it might be other police officer might also be appointed. Now, they will report the seizure. Further, what it says is, if it cannot be conveniently transported to the court. Now, if there is probably an elephant which is seized, how would you take that elephant to the court? Then you will go ahead and with the help of the police station, there is a bond maybe signed with somebody who is a mahout who is nearby, and who takes care of the elephants. So that person will take and keep it there, and whenever they required, he can bring in that elephant to the courtroom or outside the courtroom. So just an example. So this is something which is mentioned in this section. In case of something is of the order of decay, for example, fruit vegetable, this section says if it is a value of less than 500 rupees, it might be sold, and the procedure is that where there is no claimant appeared within the 6-month period of time, if no person, when such period established his claim to such property, and the person in whose possession such property was found. So 503 and 504 is something which talks about procedure by police upon seizure of property. So basically, there is a seizure which is given in 503, 504 by police, and there also it talks about how it has to be taken, disposed, and in case of decaying object, how it has to be done. So that has to be also applicable. So section 106 is a scenario where it says in one single line, it talks about the property which is seized, which is believed to be the police officer, is a property of theft and of some kind of offense. So it is not something which is done by a warrant. It is something a discretionary and a autonomous power given to the police. The police, if believes that they have seen something which is suspected to have been stolen or alleged to be stolen. Somebody comes and says, okay, there is a stolen article lying there, or it is alleged by somebody, and the police takes a cognizance of that. It's a cognizable offense. They go ahead and they can come and seize that particular thing also. And this is if it is considered to be a theft article or something which is creating a suspicion of commission of any offense, and then they have to align within police station and report it to the court, the magistrate. And if it is something which is difficult to bring to the court, somebody has to take a custody through a bail bond. Through a bond which has to be signed, not bail bond, through a bond which has to be signed, and then that person will be taking in charge after signing a bond, and that person will bring it to the court or wherever it is required to be shown at that point of time, and which something which is decaying or which could be becoming bad over time, get decomposed, those things could be sold, and the money has to be uh, kept as per the provisions of 503 and 504, and that proceeds of the sale has to be uh, uh, deposited in the coffers of the state government. So this is an authority to seize property by the police station. Any police officer who has the authority, who has an authority to seize property. So there are state government rules where what level of police officer can seize what kind of thing, and in what kind of materials they can seize. So that is something which is alleged or suspected to be stolen, etc. And then once they do it, this is how they go ahead and dispose it of. Section 107, let's move to 107, which is attachment, forfeiture, or restoration of property. So when a police officer making an investigation has reasons to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offense, he may, with the approval of the SP, Superintendent of the Police, or Commissioner of Police. So DCP or CP in our context, where we have Commissionerate-based police station, may make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or try the case for the attachment of such property. So we have seen that for attachment of property, the magistrate can act on an application of a police officer also. So this is how 107, where if the police officer believes that through an investigation that the property is derived from some kind of obtained directly or indirectly some kind of crime, through some kind of criminal activity, the property has been obtained. In that case, with the approval of the superintendent of the police or the commissioner of the police, the person can move an application to the court of the magistrate that whoever is have a jurisdiction in that area to take cognizance of the offense and commit a trial if they want, or or do a summary trial or order for an attachment of that property, whatever the court seems to be based on understanding feels right. Subsection 2 says, if the court or the magistrate has reasons to believe, whether before or after taking evidence. So there is no uh, stoppage of making a decision before even taking evidence that all or any of such properties are proceeds of crime. The court or the magistrate may issue a notice upon such person, calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. So when the court is notified, then if the court believes that it is actually in proceeds of crime, the property is acquired, in that case, they can issue the notice upon the person to come back and respond within 14 days that why the property cannot be attached. And subsection 3 says, where the notice issued to any person under subsection 2 specifies any property as being held by any other person on behalf of such person, a copy of the notice shall also be served upon such person. So if that person who has grabbed that property through some criminal activity, a notice will go to him. And also if he has deployed somebody who is maintaining that property for this him, a copy has to go to him as well to ensure that he is also informed that the person on whose instructions this property has been acquired through a criminal activity is being under the notice of the court. Then subsection 4 says, the court or the magistrate may, after considering the explanation, if any, to the show, if any is very important word here. Huh? So the court or magistrate may, after considering the explanation, if any, to the show cause notice issued under subsection 2 and the material fact available before such court or magistrate, and after giving a reasonable opportunity of being heard to such person or persons, may pass an order of attachment in respect of those properties which are found to be proceed of crime, provided that if such person does not appear before the court or the magistrate or to represent his case before the court of magistrate within a period of 14 days specified in the show cause notice, the court or magistrate may proceed to pass the ex parte order. So what it says is if the court or magistrate may, after considering the explanation, if any. So there might be some explanation coming, or there might not be coming any explanation also. So there might be a clear acceptance also coming. So if any says, if there is a response which comes and if there is an explanation there, and to the show cause which is issued, and the material fact what is available to the court in sum total. So such court or such magistrate, after giving a reasonable opportunity to hear also all both the parties or multiple party people in the parties, may pass an order to attach if they believe this is in something which is in proceeds of the crime, is it is acquired that way. And if person does not come itself, the notice itself, the person does not appear also, and the court and the magistrate may, it is all, he is also not even coming in person, or even he is not even representing his case through, even through an advocate. In that case, the magistrate will fine a ex parte order, whatever looks favorable and correct to the court. The ex parte order is without his presence, and court can make an order. Subsection 5 says, notwithstanding anything contained in subsection 2 of the court, if the court or the magistrate is of the opinion that issuance of notice under the said subsection would defeat the object of the attachment or seizure of the court or magistrate by an interim order passed ex parte direct attachment or seizure of such property, and such order shall remain in force till an order under subsection 6 is passed, which is coming. So what it says is, if the court or the magistrate believes that instead of issuing a notice, a direct attachment is very, very important, maybe to preserve the evidence, etc., etc. I just mentioned about the trademark. So on the trademark also, this is something which is applicable, where the instead of giving a notice to the person about why you are printing something which is not your logo, why you are making such boxes or printing such things, or why are you packaging such things which are counterfeit packages, the court will immediately ask for attachment and forfeiture through a receiver or a police officer, whatever it is. And that is how it is done. In those cases, courts have a power to instantly go and make those attachments instead of issuing any kind of notice to the person and seeking his or her response. Then subsection, it says that ex parte order has to be directly passed without even giving that person an opportunity and giving a note. And such property and such order then remains in force till an order under subsection 6 is passed. So that order will remains in force until subsection 6 order is passed. What is subsection 6 saying is, if the court or the magistrate finds that the attached or seizure property to be in the proceeds of crime, the court or the magistrate shall by order direct the district magistrate to ratably distribute such proceeds of crime to the person who are affected by such crime. So if they want, they can completely go back and order to distribute it to the people. Or subsection 7 says, on receipt of an order passed under subsection 6. So once this order is given to the district magistrate, within a period of 60 days, distribute the proceeds of crime either by himself or authorize any the officer subordinate to him to effect such distribution. So either he will distribute himself directly or ask some subordinate officer. And subsection 8 says, if there are no claimants to receive such proceeds, or no claimants is ascertainable, or there is any surplus after satisfying the claimant, such proceeds of crime shall stand forfeited to the government. So if the distribution has already happened, we'll still have something. Or if nobody is there to receive the distribution, then it will be forfeited to the government. It will be going to the government coffers by sale process, etc., etc. So this is an application for attachment. Subsection 1 talks about a police officer, upon establishing a reasonable belief that the property is derived from criminal activities, to seek a court order for attachment of property, he can reach out to the court and approve through the approval of a superintendent of police or a commissioner of police, and emphasize that there is a need for oversight in significant specification. So there is an oversight which is kept by the senior police officers. Then issue of notice is something which is part of this, where magistrate, if they believe the property is indeed process of crime, or they have suspicion around that, they can raise a notice to be responded back within 14 days and questioning why it should not be attached. So it is safeguarding the other person's interest also. In case of if any other person is also attached and connected and helping to maintain that property which is acquired by criminal activity, those persons, those third parties will also receive notices from the court. Order of attachment can be given after considering any explanation, if any, given by the person, or if the court believes it is indeed something which is of the proceeds of the crime. And if they fail to present their case, the court may issue an ex parte order also if they are not coming to represent or they are failed to appear or fail to come make themselves present to the court. There is an interim measure also possible, which I mentioned is normally done in the counterfeit products, etc., where in those cases an interim measure is very, very important, where it will defeat the purpose if the notice is given. If somebody is making a fake Maggie, fake Maza, fake Amul Doodh, you will not go back and send a notice to that person saying, why are you making these counterfeit products? It makes complete sense that a seizure and attachment has to happen first, and a ex parte order has to be given towards attaching and bringing those things in ambit of the court, and it has to be seized and brought to the court. So again, the subsection 6 talks about the distribution of the proceeds. So if there are courts find that the seized property is something which has to be, which is proceed of crime, it shall direct the DM or the to distribute the proceed fairly to individuals who have been adversely affected by the crime. So this ensure that basically those harmed by the criminal activity can receive some restitution, and they are highlighting the victim-oriented approach of the legal framework, where it is court is not only limiting itself to the crime and the criminal. The court is also orienting towards the possible victims also, although the victims might not even be aware of that particular matter. But court is taking a note of those victims who might be affected, and in a victim-centric approach, if things which have been seized from the person and it seems to be something which has to go back to the people who might be actual claimants of the products, it might go back to those people also, and they have to do it, and it has to be done within timely. It's within 60 days. The court has to the products has to be distributed, and if there is no claimant or there is balance which is left after distributing everybody, in that case, those things are then it's a government property. Those unclaimed assets become government properties. Empowering a law enforcement very strongly in this case, that the police officer and magistrate can take necessary action to prevent the misuse of property obtained through illegal manner or through crimes, and victims are compensated also, and the judicial oversight is across. Let's talk about section 108, which is magistrate may direct search in his presence. So any magistrate may direct a search to be made in his presence of any place for the search of which he is competent to issue a search warrant. So in whatever jurisdiction, for whatever area is competent to issue a search warrant, he can also direct a search to be made in his presence also. So the section empowers the magistrate to personally oversee searches conducted at the locations for which they have a authority to issue search warrant. It underscores basically that the role of a judicial oversight and supervision also is also being done. So this is an judicial authority to direct the searches to happen in front of his eyes, the magistrate's eyes, or he can be present to the during the search. So they can monitor the action of law enforcement officer, ensuring that the search is performed lawfully. And this kind of scope shows the magistrate must have the competence to issue a search warrant for that particular place being searched, and this aligns judicial authority also to appropriate jurisdiction. It's a jurisdiction based and ensures that the searches are regulated according to the law. So this increases the accountability. So when this kind of section is in place, the requirement for a magistrate to be present during the search directly promotes accountability for the law enforcement. They become far more accountable, reducing the risk of misconduct. Protection of rights also happen. Judicial oversight is also. This kind of searches are normally happening where when election-related crime happen, where things are stored, drug-related crime happening, where a huge consignment is found, and also prostitution-related crimes where there is a search has to happen into the red light areas to bring out the victims who are being forced into the profession. So such kind of places normally, in such kind of places where election related or some kind of narcotics related or some kind of such activities where such products has to be brought out, or prostitution related, the magistrates normally are present in such kind of search operations, because there are multiple aspects of the search which has to be looked into, and it is simply impossible that in heat of the moment the law enforcement officials might be forward doing the things with the proper uh, precautions, etc. And that is where a magistrate normally will also ask that it has to be carried in his presence. Section 109 says power to impound documents, etc. produced. Now, impound means to take over and keep it with yourself. So any court may, if it thinks fit, impound any document or thing produced before it under this Sanghita. So if any court thinks fit, they can impound any document or things produced before it under this Sanghita. Now, detail, if we please understand this authority to impound is given an additional authority to the courts. So this is given to a court. So section talks about a discretion. So it's a discretionary power. Whenever such kind of things which are switched on off depending upon the subjectivity of the matter, the discretion to impound may any document, etc. Then there is a provision which is given by the legislation to the courts to impound. And this is a very wide range which is giving authority to impound materials that may have relevance to the case or may require safeguarding due to their nature. It is something which is giving unlimited or very wide access to any kind of things. The criteria of impounding is also given in this particular section, which is to number one is their discretion. It does not explicitly defines the criteria for doing so, but if it think fit, indicates that the court exercises judgment based on the circumstances surrounding the state of the matter, that the specific case which could consider the relevance, authenticity, or potential misuse of the evidence. So basically, it is to empower the judicial process, what is happening, the trial, to empower the trial. It gives a power of unlimited materials and by just by the discretion of the judge, which is if they feel, if it thinks fit, is a discretionary power. And what is the purpose given? The purpose is so that to ensure that the documents or items that may be important for this ongoing proceedings are preserved and protected from tampering, destruction, unauthorized use, or probably theft. So this is something which is an authority given for them to maintain the integrity of that particular product and to integrity of the judgment, the judicial process. So this is a protection of the evidence under the judicial discretion and enhancing the integrity of the legal proceedings, which is secured by section 109. The last section of the set of sections 96 to 110 under chapter 8, search and seizure, is section 110, which says reciprocal arrangements regarding process. Now, when a court in the territories to which the Sanghita extends, hereafter in this section referred to as the said territories, desires that a summon to be accused to an accused person or a warrant for the arrest of an accused person. We knew yesterday that court might have a discretion to issue a summon. They might have a discretion to issue summon and then immediately after that a warrant, or they may directly issue a warrant, or they may issue a summon on failure of summon. They may issue a warrant. So that is why a summon to an accused or a warrant for the arrest of an accused person or a summons to any person requiring him to attend and produce a document or other thing or to produce it, or a search warrant, either of these situations issued by it shall be served or executed at any place within the local jurisdiction of a court in any state or area in India outside the said territory. It may send such summons or warrant in duplicate by post or otherwise to the presiding officer of that court to be served or executed, and where any summons referred to in clause A or clause C has been to so served, the provision of the section 70 shall apply in the relation to summons as if the presiding officer of the court to whom it sent were a magistrate in the said territory. So then the section 770 will be automatically applied, in which case, in the case where the very first case what is given is a summon to the said territory, summon to an accused person, a warrant for the arrest, etc., etc., summon to any person requiring him to attend, and uh, a search warrant, etc. When it is sent where within a local jurisdiction of a court in any state or area in India outside the said territory, it may send such summon warrant in a duplicate. They have to send a duplicate by post or otherwise, by any way, by a person also. They can send it through a court, any court officer or person who is authorized to do so by the court in a duplicate. Why duplicate? We have learned earlier that by duplicate, the person has to sign, or some senior officer in some cases uh, has to make an signature on top of it to ensure they are endorsing it. So all those things is to happen, and or a person has to receive the summon which has to come back into the court. The copy has to be given, original comes back to the court, and wherein summon referred to in clause A, clause C has been so served, the provision of section 70 shall apply in relation. So if in case where a session a summon is served, where the summons where the uh, provision of section 70 is also applicable, which is proof of service in such cases when serving officer not present, which means when a summon which is issued by a court is served outside its local jurisdiction, and any case where the officer who has served a summon is not present at the hearing of the case, then what happens? Or the affidavit mentioned in the section may be attached to the duplicate and all those things. So the oath can be also taken, the can also be taken on affidavit also. So that is also applicable. So in these cases, what it means is if the out of jurisdiction is given to another state, and where the court it is served by a post or by person to that particular officer, court officer, and then it can also include subsection 70 ingredients, which means if the person who has done that, if the person does not want to come physically in that particular court, he can also respond over an affidavit also. That is also which is applicable, uh, as if the person is in the same magistrate territory and providing that particular inputs. The point two says in a country or place outside India. Now, within country, it can be issued by post or by people, and then and response back through an affidavit also could be achieved. While in any country or place outside India, where uh, in respect to which arrangements of have been made by the central government with the, so we have a country level arrangement through the central government with the government of that country, and or place for service or execution of summons or warrants in relation to criminal matter, hereafter in this section referred to as the contracting state. So any, we call it as a contracting state, where the countries where India has some kind of treaty signed. In any such send, it may send such summon or warrant in duplicate to such form and directed to such court, judge, or magistrate, and sent to such authority by transmission as the central government may by notification specify in his behalf. So when a central government is only authorized to go ahead and enter into treaty, no other state can directly go and enter such kind of treaties. And if such kind of treaty of cooperation which is signed in terms of mutually accepting such kind of summons and warrants, so that country is called a contracting state for India. And in that contracting state, how the courts will send the summons in duplicate, that procedure is also given in that particular notification by the government when such an arrangement is made, or such treaty is made, and the what kind of indications are given in such kind of documentation. It is given in which format it has to go. Maybe in translation in English, in a certain specific structure of the document, directed to which court or which judge or which magistrate, depending upon how the structure operates there and what is the equivalence from the country, and to send through which authority, who will go and transmit these documents to that particular contracting state. That is also, everything is given by the notification by the central government when the treaty is entered into. Subsection 2 says, so we have seen in this section, part 1 C within India, other jurisdiction, and number 2 says within outside India in any jurisdiction where the country is a contracting state where we have a treaty. Subsection 2 says where a court in the said territories has received or service or execution a summon. So now a reverse option. Now they are receiving the summons or warrants from other places. So a summon to an accused person or a warrant for arrest of an accused person or a summon to any person requiring him to attend and produce a document or other thing to be produced or a search warrant issued by issued by a court in state or areas in India outside the state territory. So now this part 1 subsection was talking about when the summons has to be sent or warrants has to be sent, etc., to the first part, other places in the country. And part 2 of part 1 was talking about subsection 1's part 2 was talking about when the summons are sent to the other countries, the how format, etc. Now we are talking about when we receive it from other state in India, and part 2 says a court judge magistrate in a contracting state, if they send it to us in this jurisdiction, it shall cause the same to be served or executed as if it were a summon or warrant issued received by it from other court in the said territories of service or execution within the local jurisdiction, etc. And where. Now, a warrant or of arrest has been executed. The person arrested shall, so far as possible, be dealt with in accordance with the procedure specified by Section 82 and 83. So, Part 2 talked about the other country, and then it said when the warrant of arrest has been executed. So, we have received a summon and warrant from some other court, from some other place, and then we have executed that arrest warrant. In that case, when the warrant is executed, a procedure under Section 82 and 83 has to be followed, which is a procedure on arrest of person against whom warrant is issued, where Section 82 had said that when a warrant of person is executed outside the district in which which was issued, the person arrested shall, unless the court which issued the warrant is within the 30 kilometers jurisdiction, etc. So that we studied earlier, and that person has to be presented either to the same court or to the court in that magistrate in that particular locality. And arrest of such person referred to subsection 1, the police officer shall forthwith gives the information regarding such arrest and the place where the arrest person is being held to the designated police officer in the district, and so such officer of another district where the arrested person normally resides. While 82 is talking about this, this section refers also to section 83, which talks about the procedure by magistrate before whom such person arrested is brought. So they can decide, and either they may remit the person or they may decide and release the person, whatever it is required. So automatically the application of the other sections automatically apply when we make an arrest on receiving a warrant. If a search warrant has been executed, so we received a search warrant and we executed that on behalf of that particular code, originating code which has sent it to us, the things found in the search shall, so far as possible, be dealt with in accordance with the procedure by 104, what we have just studied, and provided that it is a case where a summon or such warrant received from a contracting state has been executed, the documents or things produced or things found in the search shall be forwarded to the court issuing the summon or such warrant through such authority as the central government may notify. Now, when arrest warrant has happened, we automatically apply 82 and 83, and we deal with the person, how to arrest that person, how to remit that person to that court or release that person on a bail, etc., etc. While if a search warrant is done, the materials will be obtained. If the materials are obtained within India, of course, it has to be dealt as section 104 at that particular location, and the things has to be guarded, sent back to the court, or if it is something which could be decayed and which is possible to be destroyed, then that has to be sold, and then the proceeds of the particular sale has to go back to the state, and that is something which has to be done. While if it is coming from a contracting state, the country which we have friendly terms on such areas, then we have signed a treaty. In those cases, again the notification which was given, which was talking about giving us the procedure of sending such summons through what channel, which format, etc. Also mentions the procedure. If such things have arrived through a search, if you have found such things, how would you transmit it back to that contracting country? That procedure limitation, etc. also is given in that particular rule that is followed. So basically, this is sending of summon and warrant, receiving summon and warrant within the jurisdiction, outside the jurisdiction, within India or outside India. That is what this section talks about, and it helps the facilitation of cross-border arrest, warrant issue, summon issue, or search warrant execution, or cross international border also, the very same thing. So it gives a clear understanding that you can operate it within India anywhere, and then how. And in case if you have to run it outside India, then if it's a friendly country where we have a treaty, it has to be followed by the procedures established of sending and bringing such summons, warrants, and recovery materials through the central government's notification around that about the format, procedure, etc., etc. And this gives an extra power to the judiciary. So the judiciary is sitting at one location, is empowered to send summon, warrant, etc. to the jurisdiction outside, to any jurisdiction in India, or is can also receive and act on any such summons, warrants, etc. received from other states in India or other states in the world, which is other countries. But for other countries to execute that, we need to have a treaty which is controlled by the central government and that country. So we complete 96 to 110. Now we go to section 185 and 186 in subsection in chapter 8, search and seizures. So 185 says search by a police officer. So whenever an officer in charge of a police station or a police officer making an investigation, why the other police officer will make an investigation? Because it is how the police station works and the officers will cooperate and delegate the work to those officers. So has reasonable ground for believing that anything necessary for the purpose of an investigation. So this is during an investigation into any offense which is he is authorized to investigate may be found in any place within the limits of the police station of which he is in charge or to which he is attached, and that such thing cannot, in his opinion, be otherwise obtained without undue delay. Such officer may, after recording in writing the grounds of the belief in the case diary and specifying in such writing, so far as possible, the things of which search is to be made, search or cause search to be made, or for such things in place within the limit of such station. So this is we have studied very recently section 185 in the one of the uh, previous portion, which is the chapter 3. We have studied this particular section, which was in interrogation power of the police officer. It was included there. So I'll just touch upon this because you can see in the previous video when we talked about chapter 3, and it talks about for the investigation, if a police officer in charge or a police officer making investigation from the police station, if he believes it is the only way to go ahead and make that search in the jurisdiction of the police station, the person, after recording the reasons on the in a case diary, for specifically either for where it has to be done, then what he is also looking forward to find for which reason he has to do and why it is so much necessary, they can go ahead and do that search by definitely making for these entries in the case diary. And the police officer who is proceeding under this particular action under section 1 conduct the search in person, provided that the search conducted under this section shall be recorded through video, audio video electronic means, preferably by mobile phone. So if practicable, he conduct the search in person. He has to do make the search in person if possible, and provided that the search conducted under this section shall be recorded through audio video. If he is unable to conduct the search in person, what do they do? We have spoken about it multiple times that any person who is competent to make such search present at that time, after recording in writing, then he has to delegate that person, the officer subordinate to him, and he can then do the same thing, and the subordinate officer may doing the search in a similar way. But as guided by the subsection 2, again, that person will also ensure that, if practicable, conduct the search in person. If it is not possible, the other person is doing it. If the other person is also doing it, he will follow the subsection 2 saying that it has to be done under the audio and video recording, which is most preferably by mobile phone. So subsection 1 says the reason has to be recorded in the case diary, and the what has to be searched, and a strong reason to do so, and how to preserve this evidence. And for that reason, if it has to be done, if it is not, it is practicable, it has to be done by the same officer. If it cannot be done, then it can be done by delegated officer, and the delegated officer must have a in writing from his superior to make such search, and he shall deliver to subordinate officer an order in writing. He has to give it in order in writing, specifying the place of the search and as much as possible what exactly they are looking for into, and such sort of subordinate officer may then search such things in such place, but then he will also go ahead and record it on audio visual recording. Subsection 4 has spoken about the provision of the Sanghita as to search warrant, and the general provision to such contained in section 103 shall so far may apply to such made under this section. So it is something which is applicable as per under section 103. So this section we have already studied earlier. So I'll move to section 186, which we have to see is, which is also part of chapter 3, which we have studied earlier. I'll also touch upon it quickly, is when an officer in charge of the police station may require another to issue search warrant. So, any officer in charge of police station or a police officer not being below the rank of a sub-inspector making an investigation may require an officer in charge of another police station, whether in the same or a different district, to cause a search to be made in any place in any case in which the former officer might cause such search to be made within the limits of his own station. And such officer can, being so required, shall proceed according to the provision of section 185 previous one, and shall forward the thing found, if any, to the officer at whose request the search was made. And whenever there is a reason to believe that the delay occasioned by the requiring an officer in charge of another police station to cause a search to be made under subsection 1 might result in evidence of the commission of an offence being concealed or destroyed, it shall be lawful for the officer in charge of police station of a police officer making any investigation under the chapter to search or cause to be searched any place in the limits of another police station in accordance with the provision of section 185, as if such place were within the limits of his own police station. We have seen these kind of liberties are given to the police officer to ensure their effectiveness. So if there is a possibility, then it is something which is going to delay, or for some technical reason not right, they can themselves do it. And subsection 4 says any officer conducting a search under subsection 3 shall forthwith send notices of the search to the officer in charge of police station within the limit of which such place is situated, and shall also send with such notice a copy of the list of any prepared things prepared under section 103, and shall also send to the nearest magistrate empowered to take cognizance. So the person, if he goes to the other jurisdiction and trying to do is doing that particular, executing that kind of search warrant, while he does that in the other jurisdiction as if it's part of his own jurisdiction, because he cannot disclose it to the other police station because of some kind of inefficiency or secrecy, etc. He can conduct it himself, but then while parting away from that particular place, he has to ensure that he's informing the magistrate wherever is applicable, and that person is also sharing a copy of the list of the articles which were prepared, and that is also shared with the police officer, police station, and this notice has to be given to the police station in charge, under whose discharge it is being done after this is happening. Subsection 5 says the owner or occupier of this place such shall, on application, be furnished the free cost with a copy of any record sent to the magistrate under subsection 4. So any owner or occupier of the place where its search has happened, they will also receive a copy. It's plainly reading means that. So 186 also we had studied earlier. Let's speak about section 183, which is recording of confessions and statement. So this is also we've read earlier in this chapter only, which is part of the chapter 3. But for the sake of being in this chapter, I'll just quickly go through it. This is something which is a part of chapter 13, section 183, which is information to the police and their power to investigate. And in that case, section 183 says recording of the confession and statement, and any magistrate of the district in which the information about the commission of any offences has been registered may, whether or not he has just jurisdiction in the case, record any confession or statement made to him in the course of an investigation under the chapter, under any other law for the time being in force, or at any time afterward, but before the commencement of the inquiry or trial, provide that the confession statement made under this subsection may also be recorded by audio, video, electronics, means in the presence of the advocate of the person accused of an offense, and provided further that the confession shall be recorded by a police officer or when any power of a magistrate has been conferred under any law for the time being in force. And the subsection 2 says a magistrate shall, before recording any such confession, explain to the person saying that he is not bound to make a confession and that if done so, it may be used as an evidence against him, and the magistrate shall not uh, record any such confession unless upon questioning the person making it, he has reason to believe that he is now not uh, being made voluntarily. And subsection 3 says if at any time below the confession to recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate and shall not authorize the detention of such person in police custody. So it will not cause a police custody detention. And subsection 4 says any such confession shall be recorded in manner provided in section 316 for recording the examination, etc., etc. So basically, this subsection 183, we have already dealt with in chapter 3, which is already recorded video, which is of one of the previous section lesson. And we have also seen that there is a magistrate has to definitely ensure that the person is aware of the confession and what exactly is a confession, and it can be used against him, and it is a voluntarily made, and it cannot be it has to be taken in the presence of the magistrate and was read and over person that he is admitted that he knows and understood, and the magistrate has to make a note with that regard in the particular application. And any statement other than a confession made under subsection 1 shall be recorded in such manner hereinafter provided for the recording of evidence as in the opinion of the magistrate, etc. So best fitted to the circumstances of the case, and the magistrate shall have power to administer an oath to the person whose statement is so recorded. So it is also allowed in case of the sexual offences, etc. Or the magistrate shall record the statement of the person against whom such offence has been committed in the manner specified in subsection 5, and so on and so forth. All the sections are there. So basically, what section 183 is talking about, authority to record confession and statement. It talks about mandatory warning and condition to the person making it. It talks about the withdrawal of the confession. It is also possible that the person can withdraw, and it will not authorize his detention because of that reason. A recording of the procedure is also mentioned, as mentioned in section 316 pertaining to the examination of accused individual, and recording of a non-confession statement, address statement other than confession, which allows the magistrate to record these in manner deemed appropriate for the case is circumstances is also allowed. The authority to administer an oath further is given to the magistrate, which can be done, and special provisions for the serious offences are given where which are punishable by significant imprisonment of death, etc. The magistrate may ensure that the statement from the victims are recorded promptly, and a female magistrate should preferably record a statement. If the female magistrate is not available, then in presence of a female, the magistrate can take a statement, and the post and a video recording is required. Implication of a disabled individual is also considered in this particular section, which says that the statements obtained from the individuals with disabilities with the help of interpreters or special kind of educators has to be made so that they are treated as per their convenience, and they allow the individual to be cross-examined on the statement without requiring a separate recording at the trial, streamlining the legal process. And it forwards the record of the it has to be sent to the relevant authority, which is the magistrate. So it gives a voluntary participation, judicial oversight, facilitating accessibility. I have not gone deep into section 183 here because I have already spoken in large in the same module, but in chapter 3, you can refer that video for 183. Let's move to chapter 10, which is special remand order. So information to the police and their powers to investigate, chapter 13 is talking about section 187. 187 says procedure when investigation cannot be completed in 24 hours. Okay. So this also we have studied actually earlier. So I have to go very lightly on this also. That procedure when investigation cannot be completed in 24 hours. Whenever any person is arrested in custody, it appears that the investigation cannot be completed within a period of 24 hours fixed by Section 58. And there are grounds to believe that the acquisition of information is well founded and the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the daily diary specifying relating to the case and shall at the same time forward the accused to such magistrate. We studied earlier also that the reason has to be brought in, but then the person also has to be forwarded as number of times. The police custody PC is required. And the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, they can also go back and make a decision on whether such person has to be released on bail or his bail has been cancelled. They can authorize from time the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days. We looked about this recently that 15 days is a criteria, and we have seen there are multiple permutations and combinations given under this section, which talks about the the notification and reporting by the police under this section for extending the police custody. The magistrate has a key role here to decide any extended detention, which is allows a magistrate to authorize a period of detention to initial 15 days, but limit it to a total detention to either 90 or 60 days, depending upon the seriousness of the offense. And it provides a very structured approach for the timelines for investigation and respect the right of accused. Provisions for appearances are also given here, where the mandate that the accused must be physically present every time the extension is sought, and it has to be total 15 days in all the police remands to total together done together. It cannot be always be a stretch of 15 days. A limitation on authority is also given by a magistrate of the first class and above, ensuring that the appropriate empowered officials are only making the significant decisions, and the investigative timelines, which is a 6-month limit for concluding the investigation in case it deems a summon case, ensuring a timely progress and providing a mechanism to step prolonged investigative delays, etc., are also given. Further investigation order can also be seen, which is part of this subsection 10, which allows a session judge to reverse that order and mandate further investigation if justified, ensuring that the justice is not impeded by the procedural suggestions. So practical implication is given here under this section are these. Section 192, section 193 is also covered in chapter 3. We have seen about this. I don't think we need to repeat in this at this moment. So 192 is diary of proceeding. We spoke about it in length. What is diary of proceeding? What exactly it looks like? What exactly is the content? What is the legal value? And the police report, which is the charge sheet. 193 we have seen. Let's now straight away move to 194 to 196, which is inquest proceedings under section 194 to 196. So the word basically inquest is coming from the Middle English, which means enqueste, which is ultimately derived from Latin, and then it means inquiry, but it is normally subjected to the areas where some kind of suicide, death, etc. happens. So section 194, the very first section, the three sections what we are going to read here is 194, 195, 196, and we see the inquest proceeding of section 194, first one. So the police to inquire and report on suicide, etc. So when a suicide, etc. happens, so how the police to inquire and report in such situations. That is section 194, which is important. So subsection 1 says, when the officer in charge of a police station, so when the officer in charge of the police station or some other police officer, specially empowered by the state government in the behalf, receives information that a person has committed a suicide or has been killed by another, or by an animal, or by machinery, or by an accident, or has died under circumstances raising a reasonable suspicion that some other person has committed an offense, he shall immediately give intimation thereof to the nearest executive magistrate empowered to hold inquests, etc. And unless otherwise directed by any rule made by the state government or by any general or special order of the district or subdivisional magistrate, shall proceed to the place where the body of such deceased person is, and there is in the presence of two or more respectable inhabitants of the neighborhood, shall make an investigation and draw up a report of the apparent cause of the death, describing such wounds, fractures, bruises, and other marks of injury as may be found on the body, and stating in what manner or by what weapon or instrument, if any, such mark appears to have been inflicted. So what section 1 is saying is, this is a situation, number 1, where a police officer who is in charge or somebody who is working under his delegation from that police station, and who is empowered by the state government in this behalf. So for that kind of cases, what rank is allowed, and that person has on if they receive a information that any person who has died either by suicide or by killed by somebody else, a murder has happened, or killed by any animal, or by any machinery, he has got into some machine and got killed, or he has killed by an accident, or he has died under circumstances raising a reasonable suspicion that it's not a natural death, and somebody else person has committed that kind of offense. So in all these kind of unnatural death situations, what is a natural death situation? The person is dying by age or dying over time by a long sickness. Then also it might be considered partially a natural death, which is in terms of being dying in time of the age through the geriatric issues, or somebody dying by the natural reasons which might have occurred to him and not creating any suspicion where it is impacted, affected, or affected by somebody else. So in this kind of situations of unnatural deaths, the whenever such an officer who is empowered by the state and from that police station, if the person is intimated, he will immediately give the intimation to the nearest executive magistrate also. So the nearest executive magistrate who is assigned in that area will also receive that information, who will hold the inquest. It's a executive magistrate. And unless otherwise directed by any rule made by the state government or by any general special order of the district or the subdivisional magistrate, shall proceed to the place where the body of such deceased person is. So if there is any rule which is made, otherwise he will proceed to particular place and will not stop. And there, in the presence of two or more respectable inhabitants of the neighborhood, shall make an investigation. Now, there are some special cases where the states make law, where in spite of receiving an information, they cannot move to the premises immediately. For example, some special states where there might be a terrorist activity. In those terrorist activities, if there is a death which has happened, killed by some terrorist or something has happened, the local police is normally not allowed to go there immediately. They have to give information as per the process to the executive magistrate and to the military in that area or whatever special forces working in that area. And if the special forces ask them to come, or even if they go there, they become an assisting party, but they don't go primarily in those situations. They don't enter first those areas. So in maybe this is one example. Apart from there could be many other examples. So in those areas, if it is not by any rule, they will immediately go to that particular process, and they will proceed the place where the body of such deceased person, that body is present. And in the presence of two or more respectable inhabitants, so punch. So two respectable inhabitants of the neighborhood. So they can find it from the neighborhood, two people who are respectable people, who are healthy people, who are people who have a good place in the society, and it's not financial, it's about the reputation, and shall make an investigation. Then they will start the quick first round of investigation. They will have to make an investigation. It is not just start an investigation. Starting an investigation is different thing. Making an investigation in this case is different. So they will make a quick investigation which is bracketed to the first information of this thing happening and the first due diligence what is happening. and draw up a report of the apparent case of death. So they will put an initial small report saying what is the appears to be the cause of the death. It seems like the person is executed and has died, or the person has dropped from a building and has died, or the person has a bullet injury and or a stab wound is died by a murder, or the person is hanging with a tree or on a through a fan, seems to be a suicide case, or blah blah blah, whatever the is written. So the cause of the death the person will write in the report and describe any such wound, any such fracture, bruises, etc., or other mark of injury as may be found on the body. So they will do a close examination and try to see if the neck looks to be broken, if the stomach looks seems to be bleeding, if a bullet wound is there, where the bullet is lodged, seems to be inside the body, and where it seems the bullet has gone out from the body, making a very wide hole at the backside, seems there is a point blank shot which has happened, or if there is a gunpowder which is a lot of gunpowder on the muscles around that, which shows probably from very few centimeters the person has been shot, or any such thing, whatever they see, those things has to be reported in that manner, or by what weapon also it has happened, they have to make a in report, or instrument, any kind of instrument has been used to kill that person. All those things has to be inflicted. All those things are made the part of the report. So what is nutshell in section 194 part 1 says, subsection 1 says, any police officer from the police station who is authorized by the state government to empowered by the state government and is receiving the information has to immediately go back and inform such unnatural death to the executive magistrate nearby, and if is not barred by any such laws in the state, has to go back and make an initial investigation and put accounts of all these information at one place, so that the first account of the information is available to initiate the proper investigation later. Subsection 2 says the report shall be signed by such police officer, and okay, yes, and they are also bringing two punch for in this area. So part 2 says the report shall be signed by such police officer and other persons or by so many of them as concur therein, and shall be forwarded to the district magistrate or the SDM within 24 hours. So this has to be reported to the DM or the SDM by affixing the signatures of people, whoever is present there, and so many people who can concur that, and the punch as well. Now subsection 3 says when the case involves a suicide by a woman within 7 years of her marriage. So if it is a suicide which has happened within 7 years, so all the matrimonial laws, even the domestic violence and 498A gives a special preference to the number of years within which the marriage has happened, and everywhere first 7 years of the marriage is considered a baseline, where within that if something happens is considered a higher order of crime against the woman, and more of the guilt is considered by default towards the other parties, which is the in-laws. So in this case also, if the case involves suicide by a woman within 7 years of marriage, or the case relates to the death of a woman within 7 years of marriage in any circumstances raising a reasonable suspicion that some other person committed an offense in relation to such woman, or the case relates to the death of a woman within 7 years of a marriage and any relative of the woman has made a request in his behalf, or there is any doubt regarding the cause of the death, or the police officer for any reason considers it expedient so to do, he shall, subject to such rules as the state government may prescribe in his behalf, forward the body within with a view to being examined to nearest civil surgeon or other qualified medical person appointed in this behalf by the state government, if the state of the distance admit and this being so forward without risk of such putrefaction on the road as would render such examination useless. So point 3 is a scenario which is looks very special from only one perspective, that is from women perspective. Otherwise, it is always applicable. Why, I'll tell you. So subsection 3 says the first three parts, 1, 2, 3, is talking about something which is related to married women who have entered into marriage just within 7 years of time, and this has happened, the suicide has happened. So by default, if a marriage of a woman has happened within the 7 years of marriage, if this has happened, or the case relates to the death of a woman within 7 years of her marriage. So the first one is suicide. So if she has committed a suicide within 7 years, or she has died without suicide also within 7 years of her marriage, or there is a death which has happened and there is a request made by one of his relatives on his behalf. In this is the first three scenarios, which is applicable to especially to women. Now, part four says if there is any doubt regarding the cause of the death. Now, there might be always a cause to the with regard of the death, because when you see a bullet on the person, or when you see a person hanging with a bullet also, or maybe not with a bullet also, when you see a person drowned, when you see a person in whatever scenarios dead, whatever initial inquiry by the observation of the eyes you are doing might be confusing also. It's quite possible the person who is hanging might be dead somewhere else and then he was hanged. When a person who is shot, there is quite a possibility he died by a instead of a stab also, which has happened, and then the shot has happened. Or the reverse is also possible. There might be a shot which has happened, and the stab has done nothing bad to his, which has caused his death. Or maybe it looks like he is somebody who is beheaded and the body's head is missing, and he is dead. His death has because of the beheading. It might has happened that the person was poisoned earlier and killed. So in all those scenarios, nobody can actually come back and confirm by just by seeing through ocular means, seeing and observing that there is a, they know the clear case of the death. And that is why I said this subsection is always applicable in case of such a natural death, because there is any doubt regarding the cause of the death, this section is applicable. And number four says, so five says, the police officer for any other reason, if they believe they can. So in all these reasons, what they have to do, they have to send for a postmortem to the government hospital, and they have to ensure that as much as possible it has sent to the center before it starts to decay. The body is destroying. Before that, it has to go. Subsection 4 says the following magistrates are empowered to hold inquests, namely as the district magistrate, SDM, and any other executive magistrate specifically empowered in this behalf by the state government or the district magistrate. So any of the executive magistrates can do that particular inquest inquiry. And the section talks about the notification and initial investigation by under subsection 1 by the police officer empowered by the state government, and they have to conduct a quick investigation, and they have to inform the executive magistrates immediately, and they have to visit the place to investigate until and unless they are not bound by any such rules by the state government. They have to make a quick documentation on the prima facie first findings. They have to report it to the magistrate, whatever has been coming as a finding within 24 hours, whatever report they have made. And certain considerations of the special cases of female has to be made, but if we see the special consideration mentioned, it is applicable to 100% of all the cases, which is possible, provided some cases, they might go back and not take such a step, but then those cases are rare. And conditions for forwarding the body for the examination for all the what has happened to the body, when the death has happened, what is the reason of the death, etc., etc. If the not known what is the age of the person, etc., etc., has to be ascertained. And it is the empowerment only of the executive magistrate, starting from the district magistrate, SDM, to any kind of executive magistrate who is empowered by the state or authorized by the district magistrate to go and do such kind of inquest inquiries, who can go ahead and do that. So it's a legal oversight in the investigation which is given. It is protecting basically the rights also of both the deceased and their families also, and it ensures the forensic integrity of the body, and it also brings in a community involvement where the punch and the people, whoever present, can make a signature seal there, confirming that this is what they have seen in the first information record, uh, which the police officer has made, the initial report, investigation report, what they have made. So this is about section 194, which we have seen in detail about the police to inquire and report on suicide, etc. So they are started the inquiry and they're making the report, etc., on suicide and other kind of death, etc. In the connection to the same, section 195 says summons to power to summon uh, persons. So a police officer proceeding under section 194, the previous one. So it is in relation with 194 we are talking about. May, if the police officer proceeding under 194 may by order in writing, summon two or more persons as aforesaid for the purpose of the said investigation, and any person who appears to be acquainted with the fact of the case, and every person so summoned shall be bound to attend and answer truly all questions other than questions the answers to which would have tendency to expose him to a criminal charge or to a penalty or forfeiture. So we have studied this earlier, this kind of section earlier also, where a summon, if it is given in case of this 194, the death by suicide, etc., they have to give in writing a summon to the people who he wants them, who he believes might be acquainted with the information, and they are bound to come back and they have to report and they have to answer truly all the questions given. Only if they are to which we have a tendency to expose him of a criminal charge or a penalty of forfeiture, etc. They are free not to answer that, and provided that no male person under the age of 15 years or above the age of 60 years, or a woman or a mental or physical disabled person, or a person with an acute illness shall be required to attend at any place other than the place where such person resides. So these people have to be questioned at the residence, provided if they voluntarily want to come to the police station, it is okay. Subsection 2 says if the fact do not disclose a cognizable offense to which section 190 applies, such person shall not be required by the police officer to attend a magistrate's court. So if the facts which is not disclosing any kind of cognizable offense which has happened. So it seems there is no cognizable offense which has happened, and the such persons then they are not to required by the police officer to attend any of the magistrates courts. So which we have studied 189, 190 a day or two back, where the uh, police officer can take a cognizance and they can decide what is the next step. They want to send it, they don't want to send it to the person. So detail is the explanation 195 says it is a authority to summon individual in relation to section 194 when they're investigating a matter related to 194, and this is a something which is essential to investigate, and there is an obligation to attend and answer the question if they receive a written request, a written order actually from the police, and that is something they have to respond truly to such kind of inquiries, but they have to refuse the question and answers that could incriminate them. Self-incrimination is not allowed and expose them to penalties of forfeiture. And this provision uploads the principle against self-incrimination, and that is not related to the murder or the death which has happened. Something else where it could incriminate him. Provision of the vulnerable person is also given, where the under age of 15, over the age of 60, any female, any mental, physically disabled or suffering from acute illness, those people are given a liberty that they can be allowed to answer at the residence. And it clearly says under the age of 15 only about the male, which means any male who is above 16 can be called to the police station. But then it says woman, so which is considered from age 1 to the age we are alive. So any woman and boys, males up to age of 15 cannot be brought to the police station until and unless they want to come, or their guardians allow, if they are minor, to come to the police station, and these people have to answer those questions sitting at the home. And optional attendance of the police station, that is why is given to them. And there is a non-cognizable offense if it comes out during the investigation that no cognizable offense has happened or a cognizable offense has not happened, which is in that case, the summoned individuals are not obliged to appear before a magistrate court, and this distinction helps clarify the legal. So what will happen, what does it mention is, we know that in a case of cognizable offense, then in that case, the person has to be presented in terms of magistrate. In case of it comes out to be a non-cognizable offense, in that case, no investigation further is anyways allowed. There is a bar on that. And provided a magistrate himself do not take, we also know with the studies what you have done recently is, all the people who are brought into the police station arrested for non-cognizable offences, a report has to go to the executive magistrate and the magistrates also, judicial magistrate, and if they take a cognizance and if they ask the person to come, then only the police has to make the appearance mandatory. Otherwise, for a non-cognizable offence, nobody is bound to appear in front of magistrate. In fact, that will not happen also. So this is helping to the facilitation of the investigation through 194 matters, and it protects the any self-incrimination of those people, and it also helps to cater the vulnerable population also, their rights also. The last section in inquest proceeding is section 196, which is inquiry by magistrate into the cause of the death. So 194 we have started the initial proceeding when we report what happens when we come, the magistrate receives the information, etc., etc. And 195 we talked about additional people who could be brought in through summons. 196 we talk about the inquiry by magistrate into the cause of the death. So subsection 1 says, when the case is of the nature referred into the clause 1 or clause 2 of subsection 3. So what was in clause 1? All the types of death mentioned. And what was given in the subsection 3 was the special cases. The nearest magistrate empowered to hold inquest shall, and in any other case mentioned in subsection 1 of 194, any magistrate so empowered, that is the executive magistrate, may hold on inquiry into the cause of death either instead of or in addition to the investigation held by the police officer. So they will cause the inquiry into this death either instead of, so either they are only doing it or in addition to. So they also do, or police is also doing it. Either way, whatever is required. And if he does so, so if the magistrate is the position of the magistrate is which is considered by a single gender, he. So it means both male and female magistrate. So if he does so, he shall have all the powers in conducting it, which he would have in holding any inquiry into an offense. He will have got all the power to making such an inquiry in the offense. Where now the where clause comes, any person dies or disappears, or rape is alleged to have been committed on any woman, while such person or woman is in the custody of the police or in any other custody authorized by the magistrate or the court under this Sanghita. So we know that they could be under custody of the safe house also. In addition to the inquiry or investigation held by the police, an inquiry shall be held by the magistrate within whose local jurisdiction the offence has been committed. So in these cases where a person dies or disappears, a rape has been committed on a woman, or while this person or woman is in the custody of the police or in any other custody authorized by the magistrate under this Sanghita, additional to the inquiry of the investigation, there will be always an investigation committed by the magistrate. Subsection 3 says the magistrate holding such an inquiry shall record the evidence taken by him in connection therewith in any manner herewith specified according to the circumstances of the case. So they will create, while the inquiry, they will record all the evidences which is taken by him in connection with with the manner which is further explained and which is as per the circumstances of the case. Now, subsection 4 says, whenever such magistrate considers it expedient to make an examination of the dead body of any person who has been already interred, in order to discover the cause of his death, the magistrate may cause the body to be disinterred and examined. So the magistrate has a power that if the person's body is which is uh, put under the soil, it is disposed of under the soil. They have a power to uh, power to disinter the body, and they can also go ahead and power to reverse it, and they have power to uh, still have a power to examine. So, which is a probably a situation where the person is put into the grave. We do in the Muslims and the Christians, or the person is at the stage when the magistrate wants to make an examination, has put on the funeral pyre. They put it under the woods and they're about to going to burn that person, or they've just started. In all those cases, he can recover the body and to discover the cause of the death, and they can do that. That is a power given to them. Say, for example, there is some kind of uh, death which has happened of a person which is being tried to hide from the eyes of the law. The crime has happened, and the person is immediately put under the grave, or the person is immediately put on the pyre and they started to burn that body. So in all those cases, it is power given to the magistrate with this subsection that they can disinter to examine, let the body examined and to find the cause of the death. Subsection 5 says when an inquiry is to be held under this section, the magistrate shall, wherever practicable, inform the relatives of the deceased whose name and address are known and shall allow them to remain present at the inquiry. So they can, if required, uh, they can ask for the families and the relatives, etc., to be present for the inquiry. Though that power is also given to them, delegated to them. And number 6 says a magistrate or the executive magistrate or the police officer holding an inquiry or investigation under subsection 2 shall, within 24 hours of the death of a person, forward the body with a view to its being examined to the nearest civil surgeon or other qualified medical person appointed in his behalf by the state government, unless it is not possible to do so for reasons to be recorded in writing. In this section, the expression relative means parents, children, brother, sister, and spouse. So in this case, these people can also within 24 hours let the body sent for the examination. But we know the police officer also has a power and he might have already sent it there. So that is also possible. But if it is not done, they can also do it. So that is also allowed. And if you see, there is a very clear wording put here of a magistrate that includes also the magistrates apart from the executive magistrate in such scenarios if it is required. So the relatives which is mentioned here, whom could be part of the inquiry, it is defined here as an expression. Relatives means only parents, children, brothers, sisters, and spouse. So apart from spouse, all the blood relatives are only considered relatives. See, this is an authority to hold inquiries which is given by the magistrate to the magistrate, and it is a mandatory investigation in some cases, certain cases which can happen, and evidence has to be recorded, and they have power to disinterment any body from grave or pyre also, and they have to notify the relatives also, and they have to call them for the inquiry, and it's a timely medical examination they have to ensure. It is an additional power given, although it is given to the police already to send the body for examination. But if it is not happening, for some reason, we consider everything from the city perspective. It might happen in a village perspective or small town perspective. Police has not sent the body for under pressure or under whatever situation, maybe some benefit. They're not doing it, then magistrates are also empowered to request that forensic examination can happen. So it ensures an accountability also. It brings a good support to the victim also who has died because of the situation, and facts has to be ascertained, and it preserves the evidence and it brings in the legal clarity around this. So with this, we complete the module 3, which was a mammoth and huge module. From tomorrow onwards, we go for module 4, which is bail and bond, security and maintenance proceedings.